Welcome to this AIM Quick Guide to Public Records and the Open Door Law. As with all of our quick guides, they are intended to offer AIM members an introduction to the topic. These quick guides should not be considered legal advice and should not be considered the single source of information regarding a particular topic. Should you need further assistance, please don't hesitate to reach out to us at aimindiana.org, and we'll be happy to link you with additional resources. Let's get started. Indiana law has numerous requirements to assure that the public has access to governmental records and meetings and to be informed on governmental matters. Meetings of city and town councils, as well as virtually all boards and commissions, are subject to the open door law and generally open to the public. There are some very limited and specific exceptions when meetings can be closed to the public, which are called executive sessions. An executive session can only be held for reasons explicitly stated in the law and those reasons specifically stated in the meeting notice. Notice must be given for all meetings, including executive sessions, at least 48 hours before the meeting. The 48 hours cannot include any hours from Saturday, Sunday, or legal holiday. Notice consists of posting the date, time, and place of the meeting in the city or town hall, or, if none, at the location of the meeting. Meetings must be held in a location that is accessible to individuals with disabilities. The notice must also be delivered to media organizations that have filed written requests to receive such notices. A memorandum, typically called minutes, must be prepared documenting actions taken in the meeting. Public records are also required by law to be available for inspection and copying, again with very limited exceptions. Public records are defined very broadly in the law. Municipalities can charge for the cost of reproducing the copy. The law requires government units to make a reasonable effort to make the requested information available in an electronic format if the municipality has such equipment. Public records should not be destroyed without legal authority. State law also requires that certain events be published in the local newspapers. These public notice ads are designed to inform the public about actions taken by government. There are also requirements in certain instances for a council or board to conduct a hearing before taking action. At the hearing, the public must be given an opportunity to speak. Violations of the Open Door Law and the Public Records Act have serious consequences for both the municipality and individual officials. Courts are allowed to require a violating entity to pay attorney's fees and court costs. In addition, courts can fine an entity or an individual official that has violated the law. If an official is fined, he or she must pay the fine personally. The Public Access Counselor is available to help work out differences between government officials and citizens. The office also provides training, answers questions, and provides advisory opinions on the application of the public records and open door laws. The PAC and the Attorney General publish a handbook on public access laws and cases at the web address on your screen. There are some key terms you need to know when learning about Indiana's public records and open door requirements. Review this list and be sure you're familiar with these terms. Public Access Counselor, the state employee who has the authority to mediate public records or open door disputes. Executive Session, a meeting from which the public is excluded. State law outlines 12 specific reasons for an executive session. Final action must be made at a public meeting. Notice of the meeting must still be made and a memorandum prepared. Public record, any document, electronic or otherwise, held by the municipality unless specifically exempted. Serial meetings prohibition. Prohibition for members of a governing body meeting in a series of meetings even if each meeting is less than a quorum. But the sum of all meeting attendees in the series constitutes a quorum. This provision only affects governing bodies with more than 5 members. To give you a good head start, here are some possible actions you can take immediately upon taking office and regularly throughout your term. Examine the storage method of your municipality's documents. Maintain a list of all news media which deliver by January 1st an annual written request for public meeting notices. Check with the county clerk or the Indiana Archives and Public Records Administration on the records retention schedule before the destruction of any public records. Check the serial meetings rule if one is a member of a council, board, or commission with more than 5 members. Post your meeting agendas, if used, at the entrance to your meeting room. There are also many code sites relative to public records and Indiana's open door law. It's important to reference these sites often, particularly as issues arise. The Indiana Open Door Law, Publication of Notices, Public Records Law, and Local Public Records Commissions. Some numbers and websites to have at your fingertips are the Public Access Counselor's Office and the Indiana Commission on Public Records. Both are an eager resource for municipal officials. Provided here is a checklist you can reference when creating a notice for a public meeting. Thank you for viewing this AIM Quick Guide to Public Records and the Indiana Open Door Law. Again, please note that our Quick Guides are intended to offer AIM members an introduction to the topic. These Quick Guides should not be considered legal advice and should not be considered the single source of information regarding a particular topic. Should you need further assistance, don't hesitate to reach out to us at aimindiana.org, and we'll be happy to link you with additional resources. This AIM Quick Guide is sponsored by Wessler Engineering. At Wessler Engineering, our #1 priority is developing and maintaining our clients' loyalty and trust by providing the highest quality of service and treating our clients as an extension of the Wessler Engineering family. Founded in 1975, Wessler specializes in wastewater, drinking water, and stormwater projects, providing services ranging from master planning and design to construction administration and process energy audits. Our team is passionate, skilled, and ready to go above and beyond for you. We are dedicated to bringing your vision to life with each and every project and take pride in our work. That's why at Wessler Engineering, our clients are more than a project. Wessler Engineering is the proud sponsor of the AIM Municipal Management Institute.